Hi, everybody. Welcome to TiE Dubai's inaugural legal series webinar. Today, we're going to be starting a legal series which will be focused on issues that business owners, entrepreneurs might be facing in the UAE. And with that, I'm going to turn this over to my colleague, Bianca Gracias, who is General Counsel of Suits and Advisors, and she will be leading the inaugural event today. Thank you.
Thank you very much, Tilip. Again, a very warm welcome to all our attendees. Today we have Rasha Shamat and Victor Siriani, who are both founders of Avid Intellectual Property, or Avid IP, as they are fondly called. Between them, they have got 20 years of experience, and they are actually the ones who train the lawyers at the Dubai Legal Affairs Department in the Ruler's Court. So we're going straight to the source to bring you this valuable information. So welcome, Rasha and Victor. Rasha, I'm going to hand it over to you now to start the program. Thank you.
Thank you very much, Bianca, for the introduction. And we're very happy to be part of this launch for the legal series for TiE. I'm the Marketing and Business Development Director for Avid Intellectual Property. We are a UAE-based IP company with an office as well in the US, but we do work with small to large size companies globally, and we assist them in consulting and protecting their IP worldwide. Now, our clients range in different industries, such as F&B, FMCG, IT, financial, fashion, and pharma as well. I will be joined by Victor Siriani, the Managing Partner for Avid Intellectual Property, for the Q&A session towards the end of the presentation. While IP is a vast and complex subject that requires probably more time than what we have for today, I will try to provide you with brief insight on what IP is, how important it is for your business, and what are the tips and guidelines to watch out for your business as well. Some of you may know that intellectual property plays a major role in the success of any business, no matter the size of that business, no matter when you start that business, or the industry that the business is in. Unfortunately, what we find is that some companies and business owners often neglect, or I would say to a certain extent, don't necessarily fully understand the importance of IP and how it impacts and how it is successful to their business. When we visit some of our clients, we see often that they spend a lot of time in choosing their office furniture, the color scheme for their decor, or the color scheme for their furniture in their office. However, they neglect to protect their IP because they view it as a cost. That's a misconception. Intellectual property is an asset, it's an investment in the company, and it's not a cost, because it is the main revenue generator for some of the businesses, and it builds equity and value back into your company. So what is intellectual property? What are the types of intellectual property? The types of intellectual property are trademarks, copyrights, patent, industrial design, as well as other rights such as trade secrets for your business, or in some cases, related rights. Now, related rights are also copyrights. As I've mentioned, IP is an investment. You're probably going to hear me say this quite a bit today because it is an investment and it can be monetized through licensing of your IP, through selling of that IP, or through franchising of that IP to others. In most countries, there are laws that govern IP, and they're based on international treaties and international agreements. While they are similar in so many ways, there are slight variations to those particular laws that govern those IP. So as a simple example, or as a first example that I will use, if you are to register a trademark in the UAE, you do not need to prove to the trademark office that you are using it in commerce. However, if you take the same trademark and you actually want to file it in the US, you need to prove to the trademark office that it is actually in use in commerce, or you intend to use it in commerce at a later date and accordingly prove that it is used in commerce. Why is it important to pay attention to your IP? Again, as I've mentioned, IP is an investment, IP is an asset to your business. If you look at Amazon, Amazon's trademark in February 2020 was valued at $20 billion. And I'm talking here about the trademark alone. I'm not talking about the business. If you look at Apple, Apple filed its first patent in 1977 for the Apple II computer. Now, they have over 10,000 patents. If you think of the two Steves sitting in their garage, dreaming of a big company, they had the inclination to file their patent and to protect their IP right from the start. The same with Jeff Bezos with Amazon. He did not wait to make his first million. He did not wait to generate revenue. He actually filed the trademark in the same year that he started his operation. So with both these companies, what would Apple be if they did not file their patents? And how would the value of their trademark be? How would we as consumers be also without Apple for the same? Now, for industries that are protected by copyrights, these industries can bring up to $500 billion in revenue into the US economy. And some of these industries that we talk about in copyright could be music, could be movies, could be software, and others. It doesn't only lie in companies, but it also lies in individuals that hold rights to their copyrights, such as the author for the Harry Potter books, J.K. Rowling. Look at how much revenue she generated from authoring these books, from writing these books and holding the copyright for it, from the merchandising side of things, from actually producing the movies and holding the rights to those as well. So it is very important to pay attention to IP and when you file it and how you protect it as well. When we're looking at trademarks, we talked about the types of IP. And we're going into the trademarks. What are the types of trademarks? Trademarks can be different types. It could be a word, it could be a phrase, or it actually could be a design or a drawing, a sound perhaps. If you think of the movies that we watch that are produced by MGM and we see the lion in the beginning of the movie, the lion roar is actually a protected sound mark. So is Tarzan and his roar in the movies for Tarzan in the jungle. So those are protected sound marks. The sense could also be protected for some trademarks. Shapes that are 3D, such as the Coca-Cola bottle that we have here, is also a protected trademark. Other types of trademarks are also aspects of packaging. Like you see here, I have that box, that's a Tiffany jewelry box. You can protect that aspect of packaging, and it's basically protecting the look and feel of that package. And not only that they've protected the package, they protected the color, that teal color that they have for the Tiffany box. And to add one more example here, for this particular aspect of packaging and the protection of trademark, Walmart in the US was sued actually by Tiffany for selling jewelry in a box that is very similar to the Tiffany box. So again, if there's cause to mislead the public in thinking that this particular trademark looks and feels like a protected trademark, the owner of that trademark can take action against those infringers. Another point here to mention is that the function of a trademark is to identify the origin of a good or service. So when you're looking at that trademark, you're looking at the attributes of that trademark, and it takes you back to the origin of that particular trademark. Trademarks are jurisdictional. And what I mean by that is that when you file your trademark in the UAE, it will not be protected in Saudi Arabia. It will not be protected in the UAE. And the same goes if you file a trademark in the US, it will not be protected in the UAE. You have to file your trademark in the country or jurisdiction that you want to protect your trademark in. Now, in some cases, there are some systems within the world that you can file one application and have protection in a number of countries. And as an example, the European Union, the EU, has one application that will cover all the member countries of the EU. And also there's another system which is called OWAPI, which covers all the French-speaking African countries. So you file one application through the OWAPI system, and you're covered in the, I believe maybe it's 18 countries that belong to that particular agreement. Otherwise, you need to file your trademark separately. So now that we've discussed some of the trademark types, How do you choose a name for your trademark? And this is a very important slide and a very important points that we've put together for you. Trademarks have certain guidelines and that are governed or that are looked upon through a legal perspective. The examiners of the Trademark Office take these guidelines and examine these trademarks in order to render them admissible for registration, or they object to them. As you can see here from the spectrum, the ranges for trademark names range from fanciful all the way to generic. Fanciful being the strongest name you can choose for a trademark. A fanciful name is a made-up name. It has no meaning in the dictionary. So the Kodak, Exxon, they're all made-up names. If you look at arbitrary names are names that are found in the dictionary. However, they do not relate to the business that they are protected in. So if we look at Apple has nothing to do with computers. Tide has nothing to do with detergent, and so is Camel. Camel has nothing to do with tobacco. So this would be considered as an arbitrary trademark name. When we look at the suggestive and the descriptive, they're more or less self-explanatory. Suggestive, fast loan. What is this trademark telling me? It's telling me if I send a loan, it's going to get fast to the person that I'm sending it to. If I'm looking at Jaguar is a car, is a model. What do I know about Jaguar? If I see this, I know that this is an agile, it's a fast car. It's going to get me to where I want in a fast way. So is descriptive. I'm going to tell my husband, hey, I'm going to Computerland. From that, he will know that I'm actually going to a store that will sell computers and it will sell accessories, possibly for computers. When we get to the generic side of the spectrum here, generic trademarks are not registerable, and business owner cannot have exclusive right to any generic word. So as an example, if you sell apples and you want to call your trademark apples, that will not be registered because that's a generic word. So for these, you always more or less need to add an element or a distinctive element to make that particular trademark a unique trademark. And in the case of the generic, and we have the name here, Etisalat under generic. Etisalat simply means communication. Etisalat is a telecommunication company in the UAE and in some GCC countries and the Middle East. Now, the Etisalat name should not be registered. Why? Because it is generic and because it means communications in Arabic. And the actual operation of that particular company is in communication, which makes it generic. Actually, when Etisalat wanted to file its trademark in Jordan, they were not able to register it as Etisalat. They needed to add distinctive and unique elements to it to make it registerable in the eyes of the Trademark Office there. So it is not considered as generic. So always be very careful about the trade names or the trademark the names for the trademarks that you choose, because that is also affected by a number of factors within your business strategy. That could include the marketing budget. It could be the marketing versus the legal requirements that you also have for your strategy. And also it may be determined by the product or service life cycle that you have. So those are all factors that you have to keep in mind. A fanciful name will take about 5 years to be able to build mindshare and equity to that particular name of that trademark or the brand itself. While with the suggestive and the descriptive names, those could take up to 3 years to gain that mindshare and equity in consumer. So if your product life cycle is 3 years, we do not recommend that you actually choose a name that is fanciful. On the contrary, we suggest that you use a suggestive or a descriptive name. If your life cycle is more than 5 years, then go with a fanciful or an arbitrary trademark name. It is very important at this point, once you choose your trademark and you're ready to file your trademark, is that you conduct a trademark search. Now, trademark search is not mandatory. However, it is highly recommended. Why is it highly recommended? Because it will enable us to look at the results of the search and see if there are any prior filed or registered marks that could be a challenge to your trademark. And based on that, and according to that, we can put through a course of action if we do find that there are similar or identical marks that could challenge your trademark. Another important factor in the treatment of trademarks is that when you file a trademark, they are filed in different classifications that will describe the good or the service that they are protected in. So, as an example, if you are a manufacturer of nuts and you have raw nuts and you have processed nuts, whether they're sugar-coated, chocolate-coated, the raw nuts would be protected in class 31, while the processed nuts and the sugared nuts will be classified in class 29. On the other hand, you look at someone like McDonald's. They file their trademark, McDonald's, in class 43, which is for restaurants, which is as a service they're offering. And also they file their trademark in class 28, which covers toys, because when you find some of their toys in the Happy Meals, that donates that they are also protected in class 28 to cover toys for that category. So it is very important to note that once you file your trademark, you need to choose, excuse me, the classification that it is in. And in some cases, some of the trademarks could fall into one trademark or could also fall into different trademarks. So why is it important, excuse me, to pay attention to your IP? If you do not register your trademark, you will not be able to use that right you have for that protected trademark to fight off any infringement claims or to stop anyone from using the trademark or a similar trademark. Sorry. And in fact, you won't be able to use those rights because you don't own them or you don't have them to fight off any counterfeit claims that are going against the fake products that you find. In fact, we found with one of our clients in the UAE who has a series of restaurants that we recommended to him, and we sort of told him that he needs to file the trademark name for his restaurant. And he kept putting it off until he received a legal notice from a company from Australia who had filed the same trademark name as his restaurant and asked him in the legal notice to stop using that name because it is of clear trademark infringement to their name. Now, he could have fought that. He could have gone to court and fought that. However, that would have given him a 50-50 chance to win that particular case. Why? Because in the UAE, if you are the first to file that particular trademark, you have the rights for that trademark. You are the genuine owner for that particular trademark. So he could have fought them, but that would have cost him time. It could have cost him a lot of money. And at the end, he necessarily wouldn't have won that particular case because he did not file his trademark first. So he, at the end, had to change the restaurant name, changed all the branding, packaging, uniforms, do marketing campaigns, do promotional campaigns. And at the end of all of this, he had to still register the new trademark name in order for it protected and not for him to fall into something like that. Had he gone and filed his trademark like Amazon did in the beginning, he would have had, not had this challenge, and it would have saved him a lot of time and money at the same time. If you do not register your trademark, you lose any chance in building equity into this brand. And that's also very important for investors if you've protected your IP, because they will often ask you as a business owner, have you registered your trademarks? Have you, or your IP, have you taken any measures to protect your IP? Because it is lucrative and it generates revenue. And often not, in some ways, that investors will not fund your company or will not find that particular business if your IP is not protected. So these are very important points to keep in mind. as we've said, when you protect your intellectual property, you're protecting your rights. But it's not only enough that you're protecting your rights. It is also very important to make sure that you're not infringing on someone else's rights. In this particular point here, I will bring to your attention SkyDrive case. SkyDrive was a product or service that was launched by Microsoft. What you know today as OneDrive used to be called SkyDrive. Some of us or some of you may be using OneDrive now, so it used to be called SkyDrive. The problem is that when Microsoft launched SkyDrive, they did not do their due diligence. They did not do a trademark search. They did not clear that particular trademark to see if there are any prior filed or registered marks that could be potentially a challenge for them in the name. So what happened is that they launched SkyDrive, and BSkyB, which is a British broadcasting company, actually took offense to that because they, in fact, have prior registered marks that are called Sky Broadband and Sky Go, which is a video streaming product. They went to court, and in about 6 years after the court battle, BSkyB won that lawsuit, and Microsoft had to change their name from SkyDrive into OneDrive. And on top of that, Microsoft had to pay BSkyB around £250,000 in compensation. Now, if you look at someone like Microsoft, and because it's a multinational and a large company, 250 or £250,000 is not necessarily a huge thing for Microsoft. However, for a small company, it might be detrimental, and it might cause them to cease to exist or stop operation. So it's very important that you do your due diligence and make sure while you're protecting yourself, you're not actually infringing on someone else. On this point here, these are some of the takeaways that you need to take with the trademarks do's and don'ts. What are the good practices for trademarks? Again, register it now. Don't wait until someone else registers that trademark, sends you a legal notice, and asks you to stop using that trademark. And incidentally, our client had been in operation for his restaurant for about 4 or 5 years. So he had a lot of brand equity built to that particular change it. Conduct a search to ensure no one has filed that trademark. So you're not actually infringing on somebody else's trademark. So you don't get into challenges at a later stage. When choosing your trademark, what we recommend is that you choose 2 to 3 mark names and have a few options before you decide. Conduct your trademark search, because you might find that if you've chosen one, prior filed marks could exist, and then you move on to the other choices that you have. Our model that's called Nova, that's saying no going. I would certainly not buy that car because I'm not sure if that car is actually going to take me to the point that I need to get to. So in certain cases, be very careful about the trademark name that you choose, and if you are going to file it in other markets that could have a different translation or pronunciation, that could be detrimental to that particular trademark as well. Also, another important point to note here is that consider in general and distinguish between your business name versus your trademark name. We often ask our clients, have you protected your trademark? And they will tell us, yes, we have protected our trademark, only to find out later that what they're referring to is their trade name, their business name. And in some cases, as it is used in USA, is doing business as. Your trade name, business name is not the same as your trademark name. So always distinguish that and make sure that you're protecting your trademark in the country brand, your trade is. We've mentioned with trademarks and the rights that you have. We've said that actually, if you do not register your trademark, you don't have any rights to uphold, and you have no rights to take course or take action against any infringers. Once you're protected and once you're registered your trademark, you can actually take action against infringers and counterfeits in each country where your trademark is registered through the proper authorities, be it the Ministry of Economy, be it the police, customs, and so on and so forth. If you do not protect and register your trademark, you do not have rights to take action against them. So it is very important that you protect your IP in order to be able to take action against infringers. This takes me to the end of the trademark section. I'm going to talk a little bit more here about copyrights as a second type of intellectual property. Now, what are copyrights? Copyrights are rights that are given to things that you create, such as writing a book, writing lyrics for a song, or writing a melody for a music, or at the same time taking a photograph of a scene of a person, or actually creating a movie. It also goes beyond that, and databases nowadays are also copyright protected. So you can actually protect your database if you've managed to collect so many names and have a good, robust database that you can actually protect. Copyrights are automatic, actually. They are immediate. As soon as they're affixed or created, they are immediate. They're not like trademarks where you actually have to file that trademark. Copyrights become immediate as soon as they're affixed. And the protection for copyrights is global and is immediate. So if you take a picture in the UAE and you post it onto your website, it is immediately protected in Japan, it is immediately protected in Australia, and so on and so forth. We've seen some companies actually that spring up and say, we will protect your copyright in 165 countries and we will give you a certificate. Please be very wary and ask a lot of questions about this particular company, because this is not correct. You do not have to register your copyright for it to be protected. However, that being said, in some countries like the UAE and like the US, you can register your copyright with the ministry in order to use it, should you need to use it in an action to prove or to show the ownership of that. But you don't necessarily have to do that if you are the origin creator of that particular copyright. Now, ideas, if you think of something in your head that is not protected, you have to affix it. It has to be expressed in order for it to become a copyright. With copyrights, there are two types of rights. You have economic rights and you have moral rights. Now, economic rights is very self-explanatory. It allows the owner to generate financial revenue or rewards from the works that they have actually done. With moral rights, it basically, it's attributes and characteristics of that particular artist and how it is attributed to the work that they do. So if any of his work is exemplified, or if any of his work is shown in a derogatory manner, that might affect his moral rights. You need to make sure which moral rights you actually give away, because that could also come back to you and you might face challenges with that. To also mention here that in the US, they do not recognize moral rights. However, in France and the UAE, moral rights are significant and as well available to be exercised. For the term for copyrights, like we said for trademarks, trademarks are valid for 10 years and renewable thereafter for as many years as you need. Copyrights are valid for 50 years and then they become domain name. And at that point, anyone can use that particular copyright. I've mentioned earlier that related rights are part of copyrights. And what do we mean by that? As an example, TV broadcast rights are related rights. What I mean by that is that, as an example, NBC, which is a TV station in the Middle East here, which you may know, they do not, if they're broadcasting a movie, they don't have a copyright to that particular movie. What they do have is related rights to the signal they are actually broadcasting of that particular movie. And they buy the license to actually get that related right to be able to send out that signal of that particular movie. Now, if that particular signal is reached a hotel, and this hotel broadcasts that signal into all the rooms that they have in the hotel, they actually don't have they don't own the related rights to actually that signal. It's NBC that does. So in this particular point, the hotel may be or would be committing copyright infringement on that related right. Who owns the copyright? The creator owns the copyright. The person that's affixed it, the author, the producer or the writer of the lyrics of that music, the song. As a business owner, you might think that because you pay an employee a salary, that they automatically own that that you automatically own that copyright. But it actually is not necessarily true. And in fact, in many cases, if an employee creates something, a design, writes content, or produces anything that is of a intellectual property nature that is copyrightable, this will be owned by the employee himself, unless, and this is unless, you have taken measures to protect yourself by a proper agreement that stipulates and stipulates that you own the IP or you own the copyright of that particular work that is done by the employee, and that it is signed by the employee. This is also true when you hire a freelance person to do work for you, or you engage a third-party company to do work for you. Always make sure that your agreement has the IP clause in it, and that it stipulates that you own the copyright or the IP for that particular work that is done for you. Now, in some countries, like the UAE, in France, and in Germany, if you do not have proper contract with employee, then they end up owning that IP, as well as we mentioned, freelance or third party, they will end up owning that IP. So if you do not write the contract in the proper way, you won't have the rights for it. In the USA, however, there is a slight variation to this. If you are an employee, you are considered employee as a work for hire. Therefore, you as a business owner own that right. However, it is different when you're hiring, again, a freelance or a third-party company. You need to put the contract in place and make sure that the rights are assigned to you. Now, the third point here is that make sure if you're using any images or videos and you're taking them from the internet and you're using them in your content in your website, that you actually obtain authorization to do so. Otherwise, this will be deemed as copyright infringement. We had one of the cases of one of our Middle East clients, actually. They were launching a new product, and they took a picture off of Google, actually, and they've placed it onto their website or into the section that they're actually launching, only to receive a legal notice 2 weeks later that asked them to take down that image and to pay them compensation for the use of the unauthorized image. After consulting with us, and given that it was 2 weeks and they've only used, they've only started using it, we actually recommended that they actually take down the image and pay the compensation, because if they did not, this could have escalated into court, and that would have cost them time and money to actually try to dispute that particular case. Also, keep in mind, if you are using models and outside agencies, always obtain a release form that you have and put it in order. So you are authorized to use those images and videos of these models, or else you do not have the right to use these particular shots of these models, or what it is that you obtain actually from the agencies. And lastly here, we're talking about copyright laws. Often people say, there are no, laws in place to actually protect creators of copyright or creators or trademarks for that matter. In fact, there are, and they're strong, and they are actually exercised. One of our clients, who is a professional photographer, was hired by an agency to do a photo shoot for them. And obviously, there were a lot of images that were taken. After several months, he's driving down the road on Sheikh Zayed in the UAE, which, if some of you don't know, Sheikh Zayed is the main artery within the city in Dubai road. He actually looked up and saw one of his images that he took in the photo shoot on a billboard. And that billboard belonged to another company. That company was an international financial company. So the next thing he did is that he actually sent them a legal notice to take down the billboard and stop use of this particular image, and at the same time pay him compensation for the use of that image. The company ignored him and ignored his legal notice. So the next steps he took is that he took civil action. He filed civil action case against that particular international financial company. And the court awarded him 100,000 dirhams in compensation, where the international financial company had to pay him for the unauthorized use of that image. So the laws are in place and you are protected as long as you actually can prove that you are the creator of those images, or that you're the owner of that particular trademark. So do not hesitate to look into this more if you face any issues, because the laws are in place and they are there to protect the actual owner of the IP. Lastly here, we're done with the section for copyrights. I'm going to be talking about patents. Now, patents are a huge subject matter. And because of the time limitations that we have here, what I will try to do is simplify it and make it brief. And if you have any more questions, we can take those on the Q&A session. What are patents? Patents are given to new inventions. And these inventions should have a particular use or a function. They don't necessarily have to be a new invention. Also, it could be a new invention or an improvement on an existing invention. This invention will have to be novel, new, worldwide. And I will stress on the word worldwide. The invention that you're trying to protect, it's not only supposed to be new in the UAE or in India or in Singapore. It has to be new worldwide in order for it to be patentable and registered as a patent. It must be useful, industrially applicable, and non-obvious. With patents, it doesn't have to be a rocket ship that you actually invent, and it doesn't have to be something that is of a large scale. It could be as simple as you've invented a simplified way that we can peel potatoes, for example, or we could, simplified ways to trap mice, for that matter. So it doesn't have to be a large scale, and it doesn't have to be something that is very complex that we invent in order for us to protect our patent and actually start generating revenue out of it. With those particular things with patents, also please note that generally pure business methods are not patentable. There was a case in the US, which was Alice Corp versus Cialis Bank International, which actually turned the patents that have been patented originally as a business method, they were actually invalidated because of this particular case. I'm not going to go so much into it because it's a little bit complex and long, but in actuality, what happened with this particular case is that it invalidated any business methods that had been patented as business methods in the US. Now, to a certain extent, in Brazil, in Canada, and in France, there are strict use for business methods, and if they are to be patented. However, in the US, like I've mentioned, they do not patent business methods anymore due to the Alice case. However, in some cases, if the business method could have like a technical standing, it might be considered as a patent. Now, with the patents, the patent legally protects the intellectual property rights of the inventor, and it legally recognizes that the actual invention is an invention. That is what the certificate of patent means, is that you have actually created an invention. And lastly, with the patents, your strategy for the patents. Do not divulge too much information about the invention before filing the application. That is the rule of thumb for patents. Novelty is important. It is very important, because if you start talking about it in public or writing papers about it and publishing it, it becomes less novel and it loses its patentability consideration. So if you were to write an example, if you were to write a school research paper and give too much information about that particular invention, then when you apply for that patent, it could be considered not new and the application would be rejected. So always keep it a secret until you file your first application. Patents in general, when you file a patent and you write the drafts and you write the documents, it could be an expensive process. So you can seek investors to help you in funding the investment or funding the expense of the filing of the patent and for proceeding with the patent registration and application. With patents, their term is 20 years. After the 20 years is expired, they become public domain and anyone can reproduce them, such as what we see, with generic drugs. These are drugs that are produced after a certain patent has expired. Also, for another consumer product is the Nespresso capsules. Now you find in the supermarket so many compatible capsules for Nespresso machines. Why? Because the patent for the capsules that Nestle had filed has expired and it's become public domain. So now anybody can actually produce Nespresso capsules, and that's why you find them all in the supermarket, and they're not only Nespresso brand. Patents, just like trademarks, just like copyrights, are investments. They are rewarding, and that you can sell, you can license, or you can actually offer to third party to use. So it is very important that you protect your patents like you are with the trademarks, and also uphold your rights with the copyrights, as you saw from Amazon for the trademarks and Apple, as you've seen with J.K. Rowling for the books and how much it generates revenue for the creators and for the owners of IP. With patent strategy, the rule of thumb is that loose lips sink ships. And again, what that means is do not disclose your invention to anyone and make it public, because then you will lose your registrability for the patent and it becomes less novel. And lastly, and as reiterating some of the important points that we have mentioned, your IP builds value into your company. So by protecting your IP value, you will gain revenue, you will generate revenue through your trademarks, your copyrights, your patents, and other types of IP. So make sure that you protect it. It is not a cost, it is an investment into your business, and for the long term and the short term as well. You need to protect your IP now. Do not wait until you're in business. Do not wait until you make your first $10,000 or you generate revenue or you break even. Protect your IP now. You don't want to be again caught in a place where you have not registered your IP and then somebody else tells you to stop using your trademark, or that you actually you're infringing on someone else's rights. So be very careful about that. Know your business. It is very important you know where you're going to market your products, where you're going to market your service, what is your business plan, what is your strategy on the short term and long term, and accordingly set your IP strategy to match that of your business plan. Again, with IP, it's a source of revenue. It's a revenue generating rights through licensing, franchising, or selling your IP. And lastly, as to mention that I've mentioned before, investors look and they will ask if you have protected your IP. If you have not protected your IP, you might be less attractive to them to invest in. If you look at the likes of Disney and also the franchise that they have built through their IP, it is an investment, it is revenue generating. Look at the billions of dollars that they make also from IP, merchandising, from copyrights, and from movies, and so on. So as a takeaway, IP is an investment, it's not a cost. And if you are to protect, you need to protect now. And that takes me to the end of the presentation.
Thank you very much, Rasha, on behalf of TiE Dubai and our participants today. Very, very interesting. I think very quickly, TiE Dubai is going to launch a poll right now. If I can ask the poll to be launched, and we can have a quick click on the poll by our audience before we start taking the Q&A. So Rasha, we have quite a few questions and answers here, which I believe you and Victor have kindly agreed to address.
Yes.
So quick off the bat, the first question that we have, I'm going to ask from Danny Hakim. Danny has asked, how do we search for trademarks that might have been filed already?
How do we search for trademarks that have been filed already? You need to search for your trademarks, Danny, through the trademark offices. The trademark offices have all the databases of the filed, published, and registered trademarks. So that will be the best way for you to find out if a trademark name that you've chosen has been priorly registered or filed. Do not only rely, a lot of people rely on internet and Googling. Googling will not give you a good estimate or give you an indication of what trademarks have been filed, because trademarks are usually, databases are enclosed for the trademark offices.
So Rasha, if I'm a business owner, I've invented something and I don't have the money to patent it, I'm looking at investors to come on board.
Yes.
You mentioned the age-old adage, which is loose lips sink ships.
Yes.
Which I think I will never forget now. But then do we disclose it to our investors? Because as a business owner, I may speak to 5, 6 investors, say, for example.
It is very important in this particular stage, and if you have investors that are interested or you're seeking investors, that you have a non-disclosure agreement in place that will uphold people talking about this particular invention, and it would be in the circles that you're actually talking to. So if it's 1 investor, 2 investors, or many investors, then that NDA should be in place in order for you to protect that invention, so it does not become public. And then once you go into...
Sorry,
Yes.
if I can add to that as well, Bianca. Filing a patent, yes, can be very expensive, actually.
Yes.
But if you are based in the UAE, let's say, at least file the first patent in the UAE. Once you have the first application filed, you can speak about it as much as you want. It's not a problem. But have first that priority date application wherever you are based. If you're in Pakistan, if you're in the US, etc., file your first application, and then that shouldn't cost too much money, depending on how complex the invention is.
So can you run us through very quickly? You've got patent, copyright, and trademark. Do we need to register them in each country, and how long is the protection for?
Well, okay, so trademarks, generally, when you file a trademark, it's protected for 10 years, which you can renew, and you have to file in every jurisdiction or country where you want it protected. So if you are based in the UAE and you know your business is going to extend to the GCC within the next 3 years, you better file it today in the entire GCC. But I'll give you an example. If a client comes to me and says, Victor, I'm going to launch a high-end brand of Dish Dash, the local Emirati clothes. I want to file it in Brazil. I would say that is useless because you're not going to have a market in Brazil. Why waste your money? However, if he says, I want to file it in Jordan, in that case, I would say, yeah, definitely. Because a lot of Saudis, Emiratis go there in the summer, you probably have a market, so file it in Jordan as well. So you have to file it depending on your business and how you see this is going to grow and where your market will be. For copyrights, as Rasha mentioned, you don't have to file anything. The second you create a work, whether it's a it's a drawing or a book, then you gain copyrights, and pretty much on a worldwide basis. Okay, there's an agreement called the Berne Convention. You immediately, if I right now draw something really nice, or doesn't have to be nice, but original, on the wall behind me, I gain automatic protection in Australia, in Canada, in the European Union. I don't have to do anything. But it's a good idea that I would go and take this and register it with the Ministry of Economy. In case somebody copies it, I can prove I am the original owner, and I can take action against them. Same for patents. Patents you have to file jurisdictionally. There is something called the PCT, Patent Cooperation Treaty, where you can use that to simplify filing in multiple jurisdictions, but you still have to submit the application through the PCT in the countries where you want.
That's very informative. So if I were to say there is a trademark registered in the UK, for example, and another owner comes and tries to register a trademark here in the UAE, same name, can they do that?
Yes.
Yes.
If the British company did not register their trademark in the UAE, then it is free. And as Rasha mentioned before, the story of our client, where the Australian company, which is also a restaurant, had the exact same name as his chain. And when they came to the UAE, because he didn't have it registered here, and this is actually even a worse situation because he is a local business, right? So because the trademark wasn't registered here, the Australian company was able to register it. Unless the trademark you're talking about, the British trademark, is a famous trademark. In that case, that will be a different situation, but that gets a bit deeper.
Right. When you say different, do you mean preference would be given to that famous trademark?
If it's a famous trademark, you can take different actions. So even if I register it if I take a famous mark from the UK and I register it here, or try to register it, first, chances are the trademark office will reject it because they would know the trademark. But assuming that they did not know, if the British company finds out and comes here, they can take action and cancel my registration.
And just to add to that, famous marks are treated a bit differently than regular marks that, let's say businesses that have just come up with a name that will file. So famous trademarks are treated in a different manner as well. That's why they take.
That begs the question, Rasha, how do you define famous, right?
Famous is, in some cases they have to be ruled by the trademark office that they are actually famous. In the case of basmati, right, Victor, in India?
Well, basmati is different, it's a geographic indication.
Geographical indication, sorry. But in the likes of Pepsi, McDonald's, these are famous trademarks. They're worldwide known. They are famous. They've become famous along the years. So that's sort of what defines it and what deems it.
Thank you, Rasha. Anastasia is asking us, what is an estimate cost for IP registration in the UAE market?
Do you want to take this, Victor?
Sure. I mean, okay. So first thing I will say, so you are all aware, if you are filing in multiple countries, there's going to be a lot of difference in how much it will cost you. Mainly the difference are the official fees. Okay. So to give you an example, to file a trademark in India, the official fees are about $100, whereas to file a trademark in the UAE, the official fees are $1,997. Now the UAE is the most expensive. And then you have countries in between, between those two numbers. So these are official fees, but if you are using, obviously, an agent or an advisor such as us, there will be professional fees that we will charge. So it will all depend on the market, but I hope that gives an idea.
An indication to that, there are some minimal charges that will come about in requirements of any powers of attorney that need to be notarized or legalized, depending on the country and if actually those are required by that country.
Thank you. We have a question from Rajashi, who's asked two questions actually. Rajashi wants to know, can I patent a concept of a new type of a website? Does this need a working model?
I'll give this to Victor.
Things of that nature, generally, I mean, okay. I would have to understand a lot more about what he is describing. But in general, when we get these questions, the answer generally, again, I will say no. You know, this is somewhat of, unless you have invented like a new, somehow version 3 web or version 4 web that's going to handle the website and how it works. No, but I cannot really answer this question without knowing the exact details. But I would say from experience, generally thoughts like this do not fall within the patent invention.
Can you clarify the term of the copyright registration? Is it 50 years or 70 years?
It depends. Some countries are 50 years. In the US, it's 90 years. The minimum is 50 from the date of death of the author. But some countries or jurisdictions give longer. So the minimum is 50. In the US, if I'm not mistaken, it is 90. 90 years from
the death of the creator.
From the death of the author.
Dan has
either 90 or 70.
Sorry, Victor.
No, it's just either 90 or 70. I'm not 100% sure right now.
Right. Dan has an interesting question. They ask, I'm an artist and have launched a startup for handmade customized gifts. Can I protect my designs by registering it somewhere?
I think we'd have to look at the designs, but we'd have to take a look at the designs first and see if they're unique enough to be registered and copyrighted as well.
Let me add to this. There's something, you know, because unfortunately of the time, we didn't discuss industrial designs.
Yeah.
So there's something called industrial design. In concept, it is somewhat similar to patents, but it is not for useful things. It is for only aesthetic features. So if I tell you, you know, what can
I have a live example, maybe, hold on, but go ahead, Victor.
A chair, okay? A chair is what really? Something you used to sit on. It's just this kind of like a small board with 4 legs. But you go and you see some of these chairs that are designed in a really new thing, you've never seen it. It is only for aesthetic purposes, then that can be registered as an industrial design.
This lemon juicer could be potentially registered as an industrial design. You know,
Exactly.
It doesn't look like a normal lemon juicer or an orange juicer or a lime juicer. So in fact, when you look at this, it's aesthetically pleasing and it's different, but what's the function? It juices, you know, you get the juice out of the lemon. So this is a live example that I've just kind of thought of.
Can I just interrupt for 1 second and just say to all the participants, we are going to extend a little over 5 o'clock to address all the questions because we've got so many questions going on here. For those of you who want to stay and listen to these intriguing answers and know how you can make money or lose money rather through IP, please stay on. Well, go on, Rasha. Did you have anything else to say about the lemon juicer?
No, it's aesthetically, you know, pleasing, and it's just different when you're looking at it, you know. But what is the function of it? Basically, you know, you juice lemon out of it, but it could be considered as industrial design, aesthetically different and pleasing as well.
Right.
So the answer to the question, the person who asked the question, depending on the exact item, it could be maybe an industrial design or possibly under copyright. It would depend.
Thank you. Is trade name different from trademark or are they the same thing?
No, they are very different and they have very different purposes. and very different laws that govern each one. So what is a trade name? As Rasha mentioned before, in essence, a trade name is the name you do business as. Its function is more administrative. It is for opening banks. It is for conducting business. It is for signing contracts, things of that nature. It's the entity. So for example, we have the company Procter & Gamble, which some of you probably know. Procter & Gamble has, I think, well, they have Tide, the detergent, which is a trademark. They have Crest, and they have a million other trademarks. So the name Procter & Gamble is the name of the company, but then they own all these brands. Why is this important to differentiate? For one reason. Let me give you an example. If I try to go and register I want to launch a cafe, and I think the name, the Coffee Bank, is a really catchy trademark that I can use to bring in customers and grow my business. If I try to go register it in the UAE and most countries, they will not accept it. Why? Because the word bank, they're going to say, this does not describe your activities, you're not a bank. So what I can do in that case is I will register the company as Victor Food Services, but then I will register the trademark, which I can, Coffee Bank. And then that would be my trademark, but from the administrative side, my company is called Victor Food Trading or something similar. So they are different, they have different rights and how you can, and how they are treated.
Very interesting. So Harish has a question on copyright. He asked if someone creates an e-book and promotes and sells it, does he automatically have copyright to the book?
Yes.
That was easy. Okay.
But let me just repeat, it is a good idea that before you launch it, that you take advantage, if you're in the UAE, to record that book with the Ministry of Economy, especially with ebooks, because these are going to get maybe copied and used by other people. Then you can use that recording of the book with the ministry as proof if you need to sue somebody.
Right. So then if I create a logo and do not register it, Manoj wants to know, I can still file a case on someone who registers it as trademark for infringement?
Let me answer this. This gets a bit complicated. Look, in many countries such as the UAE, Germany, France, it's a first to file jurisdiction, not first to use. If I launch my coffee place and I called it the Coffee Bank and I didn't register the trademark, Bianca, you can go and set up your own company and register Coffee Bank and then serve me with a legal notice telling me, Victor, I am the owner of the trademark Coffee Bank in the UAE. You're infringing on my trademark. Now, I cannot use the trademark law because I'm not registered. I will have to go and use civil law, and unfair competition, possibly. But it's hard in a country like the UAE, in France, and it will cost a lot of money and you have no guarantees. So yes, you can take action, but it would not be under trademark law, which would be way easier. Now, had I registered my trademark and you started using it, all I have to do, I can go, as Rasha mentioned before, in enforcement. I can go to the ministry, I can go to DED. In your country, you can go to whichever department. All I have to do is go there and I say, I file a complaint against Bianca. She's infringing on my trademark. They're going to say, prove it. Here's my registration certificate. And this is what she's using. End. So it's best to always protect your IP.
Right. So here's a question from designers on today's session. Dan especially wants to know, do I register copyrights for each of my designs? So as a licensed company, do I get copyright on behalf of the company for all my designs?
Repeat the question, sorry.
So she wants to know if, do I register copyright for each design that I have, or as a licensed company, whatever I produce under the brand of the company?
No, depending on the nature of the work, you can submit it like as a collection.
As a collection, as a series of designs.
Yeah, as a series. So it depends on the nature and if they are related, etc. So you could do like a portfolio, but you know, they're not going to take 2,000 pieces as one. They might take 50, 60 sometimes that you can submit as
a collective.
As a collection.
So Graham Perry has the $1 million question, which is on everybody's mind at the moment. Are the government fees in UAE significantly discounted now in the given scenario?
They are actually, as Victor had mentioned, the official fees now in the UAE are 1,997. That's actually for trademarks. And that's actually probably a 40% drop from what it used to be a year ago. A year ago, the fees were something like $2,800. So that's a significant drop, and it makes it easier for people that want to, register their trademarks now. They've made it easier. So I would encourage everyone to actually take advantage of this and to file their trademarks if they have been waiting.
And just so you know, like for copyrights, to record the copyright, I think it's about official fees, $300, roughly, a little less.
A little less, actually. A little less than that.
For recording or registering the copyright, it's much cheaper. Patents, I think they are in the range of 1,500, something like that.
Plus the annuity fees for 20 years, but they don't amount to too much. There might be $100 per year or $200 per year.
So would you say $300 to register copyright is a good time to start writing a book then?
Yes, of course.
So
absolutely.
To say this is a question for all the tech startups out here. When they develop their software or they develop their application, what are the things that they can register as owners?
For software, usually it is in copyright. So if it's a pure software such as Excel, their codes for Excel would be protected under copyright. Now, a software that is that works with a device and has real, let's call it a real world effect, then it could be patented. So I'll give you an example. So Excel is just pure software that you use on your laptop. That's a copyright. Now, the software that is used for typing on your mobile, with the digital, that actually has a real world effect, and it's used with a device. That's patentable, or patented, actually. It was, at least. So there's a difference between the two. So it depends on the situation, but you're either going to look at software or you're going to look at patent potentially.
Or also your trademark of that particular software.
Well, and the trademark, of course.
That is a given, yeah.
Right. Would you advise having non-disclosure agreements with freelancers? I know it's a cool thing to do in this part of the world where we hire freelancers, consultants, because startups in particular cannot afford to take on board full-time employees. Would you recommend having non-disclosure agreements in place with them, or even with lawyers? What about lawyers? What about hiring yourselves? If I were to come and hire you to register my patent or my trademark, do I need to sign an NDA with you?
Not really. Look, when we are working in this type of field, there are certain ethics that we work with. But I mean, if I've had clients who said, "Oh, I need you to sign an NDA." Okay, fine.
Yeah, we don't have any issues with it, but it goes with the confidentiality, between the client and the company.
Yeah.
Now, in cases, go ahead, Victor. Yeah.
But if you are dealing, let's say I want to launch a new marketing campaign and I hire a photographer, okay, why not sign an NDA? But more importantly is to sign the contract. I ensure that the work he does, the pictures he takes for me, that all the rights are assigned to me. If I don't do that, then the photographer can take those pictures, although I've paid him money for it, he can take those pictures and license them to somebody else. So more important than the NDA so much as far as we're concerned is whether you're dealing with employees, as Russia mentioned, or with, you know, outside
agencies, third party, or freelancers.
or agency.
Right.
That,
I want to know, in terms of mobile application development, Isam wants to know if he has a mobile application development concept, where would that be registered?
well, if it's considered a copyright, then we can register the copyright, which is really the coding of that particular application, with the Ministry of Economy.
Right. And if I need to register, say, a trademark, a copyright, or a patent, or a design, can I register it in my individual name, or do I need to be a company, and do I need to have a trademark to my company registered?
Okay. Do you want to answer this, Rasha?
No, it's okay. You can go ahead.
Okay.
You started. That's fine. I've spoken for some time. You can take ahead.
Yeah, I'll give you a break.
Taking a break.
You have to understand that, as mentioned earlier in the presentation, in all countries, purpose must be to be used in commerce. If I walk into a trademark office and I say, I want to register a trademark, but I have no intention in using it in commerce, they will not accept it. So you must have that intention to use it in commerce. But the treatment differs from one country to the next. As Russia mentioned, in a country like the UAE, they don't ask for proof that in your own name, in the company name. But if you cannot produce a trade license, it will not be accepted. Now, here's the funny thing. If you are a resident of Lebanon or Pakistan and you want to file it under your own name, you don't have to provide any sort of trade license. So only if you're a resident of the UAE, you must show that you have a trade license.
But as an individual in other countries, in other countries in the world, I believe that you can file as an individual, and it doesn't have to be a company. Yes, it's not an issue.
So on that note, Rajiv has a very interesting question. He says, if copyright is valid for a minimum of 50 years after death, what happens if the copyright is in the name of a company which never dies?
The companies are 50 years from date of publication.
Right. I have Kimberly asked a question. She says, I see there are multiple companies online that indicate they can search your trademark name. Are these sites safe to use? Is there any official international website where I can search for a trade name?
Not really, because if you think about it, every single country has its own trademark office, and every single trademark office has its own data. So you cannot have that as on an international basis, basically. So you have to go per country that you're interested in filing that trademark in order to conduct that search in that, because that will give you the true result of what's in the database and what could be, filed, published, or actually, registered at that point.
So another point to indicate on this, some countries you can access their trademark database to see what is registered or applied. For example, in the EU. In the United Arab Emirates or Saudi, you cannot. You have to pay for each search. So a lot of these database companies, they might have the information on the publicly available jurisdictions. So they might have the US, they might have the EU, etc., but they will not have Saudi and the UAE. On a different note as well, If they have the UAE, they will have the marks that have been published. So very briefly, I'm going to say this because it'll take too long. When you file an application, it goes through an examination stage. Now, these companies can't take those publications and put them within the database. So you've only seen the trademarks that were approved. But if there's a trademark that was applied for, but still hasn't gone through examination, you will not see that. And then you'll be surprised. Because when you get this report, you'll go like, oh, okay, my trademark is not here. Great, but this is published. But there could have been the same trademark filed, but not yet published. Then when you apply, your application will be rejected. So you have to be careful with these things. And in the end, to be honest, you know, and this is what we do, is it's not just having the search, is interpreting the results, you know. This makes a big difference on the decision. Do you move forward or you don't move forward?
Right. I'm mindful significantly over time, so I'm going to take the last 3 or 4 questions very quickly if we can. We've got our charter member Himanshu asking, in the SkyDrive example that you gave, did SkyDrive register the IP in the UK already before using the name?
No, they did not.
Too bad for them. And Himanshu also wants to know another question. If I have a photographer and model in Kenya and office in the UAE, will the same model release form now work?
Yes.
Is this a standard
Yes,
form?
as long as you have a release form, okay, that's the main thing. Now, if there is a dispute in Kenya, it's not an issue. You have the model release sign in Kenya. However, if the problem comes to the UAE, then all you need to do is go through the formalities of attesting the document so you can take possibly legal action in the United Arab Emirates. But it is extremely important that as Rasha mentioned, when you are using models, always use a release form, and important in the release form that they are not allowed to use that picture, because in the UAE, you know, we say the UAE, but it's not the UAE only. There will be a number of countries around the world. If I take a picture of you, Bianca, for, you know, marketing my business, and the picture is only of you, by law, you can take that picture and use it as you please. I cannot stop you. But if I sign the proper contract where you release all your rights, then you will not be able to use it in, you know, for any other purpose. But as well, the photographer has his own rights as well. He is the copyright owner, unless my agreement with him rights to me, or use it somewhere else.
Right. Can I ask you, is IP infringement a criminal offense in the UAE?
So, okay, there are 2 types of infringement. There is, let's call it an innocent infringement, or just your standard infringement. And then there's counterfeits, okay? Counterfeit is a type of infringement, but it's a much more serious thing. So your standard infringement where, you know, I go somewhat copy the design of McDonald's, or I call my hamburger spot Burger Queen. Burger Queen would no doubt be an infringement against Burger King, I'm telling you. But it would not be a criminal offense per se. Why? Because my intention is not to trick the consumer to think that this is Burger King. I'm just
get some traffic into Burger Queen.
Ride their coattails, get some traffic, you know. Yeah, Burger King is nice. I'll go with Burger Queen. And many times, like with the SkyDrive, it's a mistake. Microsoft had no intention to fool people to make them think that they are B-Sky-B. They don't have that need. So this is more of a civil case where you can take action, civil action, you can make complaints, you can go to court, get compensation. So B-Sky-B got £250,000. Counterfeits, on the other hand, this is where the criminals, because it is a crime, their intent is clearly to fool and deceive the consumer to thinking that this fake phone you're buying, they put an Apple on it, that this is actually the Apple product. Now, this is a criminal offense in all countries, and there are jail terms, there are fines, and then you as a trademark owner can still take civil action to get compensation. And of course, through the civil action to destroy all those fake goods. We deal a lot with a tobacco company that, you know, there's a lot of shipments that sometimes come either from Pakistan, from Vietnam, and I think one's from Cambodia. The shipments are counterfeit cigarettes, okay? It has their name and everything, the same as our client. So we use customs a lot to stop these, to destroy the cigarettes, not to let them in. You can't always go after all criminals because sometimes the criminals are not based here. So it becomes complicated. Yeah, but it's a really interesting thing to work on. Cigarettes are the biggest or the highest counterfeit products in the world. But I will tell you as well, so you have an idea. Sorry, it's a bit maybe too much information. Medicines, pharmaceutical products are obviously a massive problem. And even in the European Union, according to a study by the World Health Organization from like 2010, about 30% of the medicines in the EU are counterfeit. So these problems are not just in our region or in the UAE, it's a worldwide problem.
We're running out of time, Victor. Unfortunately, in Russia, we're really running out of time. I have one last question for you, and I want you to answer that in 60 seconds if possible, because we have to close by 5:30, no pressure.
Okay.
I'm sure you guys have fun lives by all the stories you've been telling us until now. I just want to know if at all my trademark is infringed, my copyright is infringed, my patents infringed, what are the next steps? 60 seconds, go.
Come to us, we'll serve them a legal notice. If they don't do it, depending on the situation, we can complain with the ministry. We can file a legal civil case, of course, through our partners, the law firm. We can't do it. Or if it's a counterfeit, depending on the situation, go file a complaint with the Dubai police, the anti-commercial fraud, and get them raided, product seized, and hopefully stick them in prison.
That's if they're local and in the country. If it's customs, then we go to the authorities of customs and take action there as well.
Thank you very much for your time and for answering all these questions. I would ask all the attendees, if you have multiple questions regarding processes, you can drop an email to us at TiE Dubai. Our email's on our website, on our Facebook. Write into us and you will most definitely be connected directly to Russia and Victor, who will be more than happy to answer your questions.
Thank you.
Thank you very much, everyone.